Yeah, Neil, it's fascinating here because the defense chose not to put on a case or put on resistance to the first part of this penalty phase, where the prosecution was putting its own case forward for aggravating circumstances that would justify the death penalty. In the order of things, it's probably better the defense is laying all of it out right now, so it's fresher in the jury's mind, isn't it?
Potentially. There, of course, as in trials, in cross-examination, opening statements, closing arguments, excuse me, really in almost any presentation, you've got primacy, recency. You always want to lead, and then you want to sort of have the last word, so that information remains with the jury. That, like any commercial, you remember the beginning, you remember the end, you don't really remember the middle. The concern here for the defense has to be that is the jury's mind already made up? Are they going through what we like to refer to as jury fatigue? Have they already leaned so far in one direction because of the evidence that's already been presented, and the fact that now, with all that evidence that's been presented so far, now the defense is attempting to make its case? Which way are the jurors leaning? So yes, the recency can certainly can play a factor. It can be an advantage to the defense. I'm going to add something here, though, and that is that the smart play also may be that the reason why the defense is doing this, and it may be a smart move, is that there's so many aggravating circumstances here. There's so much aggravating circumstance that in order for them to take what mitigation they have and not spread it out over the course of months, and really take the mitigation and focus it just in a matter of a short period of time, this may be a way for them not to dilute their evidence. This may be a way for them to sort of condense it, and not just to have it recent, but to really put it all into one box at one time. And if they had spread it out over a long period of time, it could be very diluted and really could not and would be less effective.
And of course, the prosecution does still have its chance to cross-examine the defense's witnesses. And Neil, all it's going to take is one, right? Just one juror to say, no, we're not going to kill the guy.
That's right. This testimony is really about developing a history showing that this wasn't a young man who began his life and developed his life as someone that was excelling and doing well and just gravitated towards evil. What the defense is trying to do is to have a school counselor take the stand and testify about a young man who was struggling in school, and painting a vivid picture to the point of how he would grab graded assignments and want to take them and almost hide them so that he wouldn't be embarrassed or feel ashamed or feel less confident or mocked by having to have that and show his grade to others. And I think going back to middle school and even further was important, because it shows that this is something that was building, that this young man was struggling, and the system wasn't able, and the public and the community and the school system and his family weren't able to actually help him. This testimony, as you pointed out, is going to go right to that one parent or that one person on a jury who can relate, either themselves or with a loved one or a child or others, someone who struggled. And they're going to think to themselves, you know what? But for what happened to me or my child or my family or my loved one, God forbid, he could have ended up like Nicholas Cruz. And hopefully they're going to find some connection there. And that is what this testimony is designed to show.
Yeah. And of course, the state is going to try to make sure that that doesn't go all the way and doesn't affect the jury in that way. That was pharmacology expert Dr. Susan Scully-Danziger in her testimony from yesterday, and she was talking on direct examination about the defendant's current medication plan. Now, I do want to bring in now our guest today. It's a former prosecutor and trial lawyer, Darren Gelber, and along with him, the criminal defense attorney, Neil Rockind. Now, thanks to both of you for coming in on the record today. Now, I'll start with you, Neil. Why is it important for the jury to know the medication that the defendant is currently on? Does it add anything to the defense case?
It can, and it's great to be here. It can add something to the defense case. It depends on the defense case. The defense here is attempting to establish that Nicholas Cruz has essentially that he's a child, but that he has deficiencies, mental deficiencies, that he wasn't capable of thinking properly, that he has certain setbacks and disadvantages mentally, pharmacologically, and toxicologically, and that this medication was given to him to help him, and that he's not in and of itself just a bad person. It's designed to show that he has challenges that he can overcome with proper medication and proper oversight. It is, from my perspective, just a very tall order for the defense to attempt to, but they're doing the best they can. Sometimes you just aren't dealt a very good hand, and this is that case here.
Yeah, it sure is. And Darren, the defendant's medications weren't filled for about 5 months leading up to the shooting.